Your case has gone all the way to trial, and now, at the end of the trial, the jury wants to have not just some of the testimony read back, they want all of the testimony read back. Can they do that? Can they ask the judge to have all the testimony read back? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury. The doctor turns around and says, hey, I did nothing wrong. Why are you suing me? And if I did something wrong, guess what? Whatever I did not cause or contribute to your injuries. And then he turns around and says, you know what? If I did something wrong and whatever I did caused you harm, yeah, your injuries really are not that bad. And then he says, hey, you know what? I am never going to settle this case. I'll see you at trial. All right, so now 2 years down the road, your case finally comes up for trial. Your case is on for trial for 2 entire weeks. And now, the jury finally gets your case. The judge gives the jury instructions on what to do, on what questions they have to answer in order to reach their verdict. And now, within 20 minutes of getting the case to now deliberate, the jury comes back with a written request that says, Judge, we would like to have all the testimony read back to us. Can they do that? The answer is yes, they can. They can ask the judge to have testimony read back. But I have to ask you something. Is it reasonable for the jury to turn around after listening to testimony for 2 entire weeks, to turn around and say, hey, Judge, could you do us a favor? Could you have all of the 2 weeks of testimony read back to us? In my opinion, no, that's not reasonable. And it's highly unlikely that the judge will allow the jury to have all the testimony read back. There's a very good chance that the judge will turn to the jury in response to that question and say, listen, if there's something specific that you want read back of a particular witness's testimony, then I will be happy to get the court reporter to come back to identify that section that you want read back, and I'll have all of that testimony read back. Question, answer, even if it takes a long time. But in all likelihood, he will not allow the jury to have all of the testimony read back because that really is a waste of time. He's going to turn around to the jury and say, listen, ladies and gentlemen, you have to rely on your own memory of what you recall occurring. And if there's something specific that you want read back, sure, I'll be happy to have that done for you. But all of the testimony? No, you guys were here just as we were, listening to all the testimony for the past 2 weeks. So why do I share this information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice trials here in New York. You know, I recognize that you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do if you have not yet started a case is to pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.